Hello, hi, and welcome. So, the fourth chapter in module 2, which is the last one, however, very important with respect to your examinations. Because the rules of construction in the previous chapter, by and large, are overlapping with the interpretation of statutes. So mostly the questions will come for your examination from the fourth unit, which is very elaborate and which is very crucial for a student who is doing a specialized study with respect to administration of enactments or ensuring compliance with respect to the acts that are being made by the legislature. So, in this chapter, we will be coming across the various interpretation issues with regard to the statutes, deeds, and documents. So there is a you will have little introduction and its importance that you will come to know before going for rules of interpretation. The rules of interpretation of statutes are very important, and these are further classified into primary rules and secondary rules. And you may likely get a question asking about the primary rules or the secondary rules. Both may not be clubbed together because the primary rules are very lengthiest, and within the primary rules also a specific rule can be asked in your examination. So here students have to keep a focus on specific rules and as well as the rules together that comes under primary rules. And the secondary rules are relatively less, and there can be a likely question over the secondary rules as a whole. So if at all a question comes under the primary rules, the student have to give the gist of that rule instead of writing the whatever the content available in your course material. The course material here is exhaustive. You may not be able to produce it as it is, or the quantum you may not be able to produce, and you may not require to produce also. And your understanding of that rule and the gist of the rule you need to produce in your examination. And certain aids to interpretation of statutes are there, so they are further subclassified into internal aids for interpretation of statutes and external aids for interpretation of statutes that are made by the legislature. And when it comes to the rules of interpretation of deeds and documents, this is being given as a separate topic. In fact, we in the profession of finance and accounts, and as a tax administrator or as a tax consultant or as a person who is helping the management of the company with regard to compliances under the Companies Act, etc., you need to help the management to understand to understand the interpretation of the various deeds and documents that are entered into by the corporate with the outer world. So these rules of interpretation of deeds and documents, along with understanding and interpretation of the certain statutes which are applicable to the corporate entities, is very much important for the students who are studying the course of chartered accountancy. Only with the understanding of these rules of interpretation and the various aids available to interpretation and the rules of interpretation of deeds and documents, a student or a person whoever is in profession can do the best service to the organization for which he is working. So here, when it comes to a brief introduction, that what you are going to study here, it is we are going to know about the interpretation of statutes apart from the deeds and documents. And here you need to understand what is the meaning of a statute, and what is the meaning of deeds, and as well as what is the meaning of the document, and what is the meaning and what is exactly being understood in business circles about the words like instrument or a deed, etc. So when it comes to a statute, for your understanding, so in general, we think a statute means a law or a laws and the regulations of every sort. We generally considered it as a statute. Statutes generally we consider the laws and statutes, laws and the regulations that are emanated from a certain authoritative source, that we consider them as the statutes. So these statutes do have been defined as the written will, written will of the legislature, and it is the legislature which passes various bills, and once these bills are being approved, then it will become a statute. So which mean to say this is the will of the legislature. The will is not just the unwritten will, it is expressed in the form of the written will. So that is why statutes are the written will of the legislature, which has been expressed to constitute it the law of the state. Here state does not mean the a state in the nation. Here the state means a nation, for the country as a whole. That in that context you need to understand the meaning of the word state here. So the next is that the document. Oh, document. So this definition of a document was given in the Indian Evidence Act 1872, which states that document means any matter expressed or described upon any substance by means of letters or figures or marks, by more than one of these means intended to be used. So for the purpose of recording that matter, so which is called as a document. So as per this, any matter expressed or described upon a substance by means of letters, etc., for the purpose of recording that matter is called as a document, in line with the section 3 of Indian Evidence Act 1872. And there are various elements in a document. So if a question is being asked, write about the document, the meaning of the document, and what are the elements that are involved in the document. So here there are four elements. One is the matter. It is the first element, and its usage with the word any shows that the definition of the document is comprehensive. And the second element is record. Must be a certain mutual or mechanical device employed on the substance. So normally we use writing a document through the computer by using some software, and wherein we record the substance. We record the substance accordingly. So the substance recording must be by writing, and it should have an expression. Expression should be in the written form, or it could have the description. The description of the substance must happen during the second element. The third one is it is a mental or intellectual elements comes to find a permanent form. So substance means there will be an idea, a thought which emanates from the intellectuality of the prudence of an individual. So that comes to find a permanent form by recording it as a matter. And the means says that such a permanent form is acquired, and those can be the letters or any figures or some symbols which can be used to communicate between two persons, right? So these kind of things are to be there in the document. When we go for a document, it facilitates a communication between two persons. So when that is to be communicated, the means of the communication is the either letters or figures or certain marks or symbols. So these four constitute as the elements of a document. So students, you need to understand, if a question comes to ask you about to write about the documents on and its elements, you need to write about what does it mean, the document in accordance with the Indian Evidence Act 1872, and also what it constitutes in the form of various four elements. And these are the four elements you need to write about. And the next concept that you should know is the instrument. So we have seen the meaning of an instrument in the Negotiable Instruments Act. So in general, instrument means a formal legal documents which creates a right, a fact, or it is a formal writing of any kind, such as an agreement, deed, charter, or record. So these all are the various ways of the instruments. And instrument includes every document by which any right or liability is to be created or transferred or extended or extinguished or recorded. So that is called the instrument, what it includes. And it is every document by which any right or liability is to be created or transferred or extended or extinguished or recorded. So the next is the deed. And simply stated, deeds are instruments, though all instruments may not be deeds. And in India, there is not much distinction between an instrument and a deed is concerned. Instruments includes every document, but all the instruments need not be deeds, but all the deeds are the mostly instruments, we can say. And interpretation meaning the process by which the real meaning of an act or a document and the intention of the legislature in enacting it is ascertained. So you know that as and when an act is being made, it will have a different meanings when you go through it. So the individuals can attribute in different meanings to the different words that are being there in the statute. So these different kinds of interpretations, if it is harmonious, there is no issue at all. When it is conflicting, then the problem comes. So what is the right interpretation of the provision that is there in the act will be decided by the courts, right? So the courts will how to see the right kind of interpretation with respect to the certain rules of interpretation. Right, there are certain primary rules and there are certain secondary rules for interpretation of various provisions whenever there is a conflict of the meaning of that provision between the people when they are been working on the same provision. So there is a lot of importance for the interpretation, so is a familiar process and we can say it as a significance also. Interpretation is of importance because of its inherent nature of legislation as a source of law. Why it is becoming important means the nature of legislation as a source of law. Legislation is the only source of law. The process of statute making and the process of interpretation of statutes take place separately from each other, right? So where you understand the status, the process of statute making, where it takes place, process of statute making will takes place in the parliament, and the process of interpretation of statutes where it takes place, the process of interpretation of statutes takes place in the courts. So these are separate from each other, and these are two different agencies. An interpretation of act serves as a bridge of understanding between the two agencies that are employed. So this is what you need to understand, and because the process of statute making and the process of interpretation of statutes are being dealt by two different agencies, and normally it gives a lot of significance for interpretation and use of rules of interpretation of statutes, and there the courts will take into account the primary rules and the secondary rules as per applicable while interpreting the statute, in order to give the exact meaning, in order to give the possible best meaning of what the intention of the lawmakers behind it, which was written there, which was not written there. However, by interpretation, the courts will bring out the true intention of the lawmakers behind the provision. Right, students? So that is the more important point of the interpretation. So, when you come to the classification of interpretation, there could be a general classification of interpretation. One is a legal way of classification, and other one is the doctrinal way of classification. So, legal way of classification again further subdivided into authentic and usual. And when it comes to doctrinal interpretation, again it is further divided into grammatical and logical. So these are the broad classification of interpretation. Interpretation is usually said to be legal or doctrinal. So let us see what is the legal classification. When there is an actual rule of law which binds the judge to place a certain interpretation of the statute, that is called the legal interpretation. Right. Whenever there is an actual rule of law which binds the judge to place a certain interpretation of the statute, it is the legal classification. And a doctrinal, when its purpose is to discover. So whenever there is a something to discover out of the provision of the statute, then the doctrinal classification comes into picture. The purpose is to discover. The students has to remember this word discover. So the doctrinal classification is to discover. Doctrinal is to discover the true meaning of the statute. What is the true meaning which was not written there, which was there in the minds of the lawmakers? That is to be discovered through the doctrinal classification of interpretation. Right? Legal interpretation is again further subdivided into authentic and usual. Legal interpretation is again further subdivided into authentic and legal. So, it is authentic when the rule of interpretation is derived from the legislator himself. So, where the legislator himself gives the rule of interpretation, then such a thing is called as an authentic way of authentic legal classification. Right? When it is usual, when it will be called usual, when it comes from the other source such as the custom or case laws, that is the usual legal classification. So authentic legal classification is different from the usual legal classification. Students have to understand, authentic legal classification means that the rule is being given by the legislator. The interpretation rule is being given by the legislator himself. When it comes to the usual legal, it comes to the based on the custom or the available case laws will be the guiding force behind the interpretation. So that is the classification of the authentic legal and the usual legal. Right. Now we go to doctrinal classification. And the doctrinal classification, no, grammatical classification is there and the logical classification is also there. So it is a doctrinal grammatical classification when the court applies only the ordinary rules of speech. When the court applies only the ordinary rules of speech for finding out the meaning of the words used in the statute. You understand? Whenever the court applies only the ordinary rules of speech for finding out the meaning of the words in the statutes, then it is called as the grammatical way of classification. Right? So when it is called as the logical, on the other hand, if the court goes beyond the words and tries to discover the intention of the statute in some other way, then it is resorted to a logical interpretation. So whenever the court goes beyond the words and tries to discover the intention of the statute in some other way, then it is called as the logical interpretation. Students, you understand? Your text has given, the text in this course content is given more and more, which is not required to that extent for you. You need to understand, if a question comes, what are the classification of interpretations? You can straight away say, broadly there are two kinds of classification. One is the legal classification and other one is the doctrinal classification. The legal classification is further subdivided into authentic legal classification and usual legal classification. The doctrinal classification is further subdivided into the grammatical classification and logical classification. So authentic classification, what it says is that where the exact rule is being given by the legislator, and when it comes to the usual, it goes beyond the rule and it goes based on the law customs and the customs and as well as the case laws will be the basis for interpretation. When it comes to the doctrinal, the grammatical means it goes by the exact text as it is given in the statute. The logical means it tries to discover something beyond, and it tries to read the minds of the legislator behind the intentions of the legislature will be discovered through the logical doctrinal classification of statutes interpretation. Students, you understand the beauty of it. So it is very very interesting when you have a true spirit to know the interpretation. If tomorrow you becomes the tax consultant, unless you interpret the provision of the tax in the right way, you can never advise your client in the proper way. You should be able to interpret. You should be able to interpret the provisions of the tax rules and the tax provisions in such a way which will reflect the intentions of the lawmakers, which was not written in the text on your bare act. So this is the different kinds of interpretations which will be possible. And next is you let us have an understanding of what is the meaning of interpretation and construction. Students may get confused, right? So the difference of it is not much. Both are interchangeable, and it denotes the process adopted by the courts to ascertain the meaning of the legislative form in which it is expressed. These two terms have different connotations, right? So here let us see what is the difference between the interpretation and the construction. Interpretation differs from construction. Interpretation is of finding out the true sense of any form. Interpretation is always a finding out the true sense of any form, and the construction is the drawing of conclusion respecting subjects that lies beyond the direct expression of the text, right? Construction means it goes beyond what is there in the form of text. So construction of a statute means you need to read the minds of the lawmakers behind making such a law, such a provisions. The real intentions of the lawmakers are to be discovered when it comes to the construction of the statute. You understand, students? The construction goes beyond the text, what it is mentioned. The construction goes beyond the text, what it is mentioned in the bare act. When it goes to the courts on any disputes with regard to the interpretation of the provisions which are there in the bare acts that we commonly give consult to different clients on day-to-day basis. And right, so the courts adhere to the plain meaning of the language used by the legislature. It would be interpretation of the words, but where the meaning is not plain, the court has to decide whether the wording was meant to cover the situation before the court. Right. Right. The next important topic is rules of interpretation or construction. So I told you there are certain rules of interpretation. There are certain primary rules and there are certain secondary rules. What are the rules of interpretation? So over a period of time, certain rules of interpretation have come to be well recognized. See, the courts, when they keep on trail the provisions which comes into disputes, they do the various rules have been evolved by the courts, and these rules are considered as a guides only, and which are very very flexible. The rules are guides and they are very flexible. These rules can be broadly classified into the primary rules and secondary rules. So you may get a question straight away asking you to enumerate or list out the primary and secondary rules. So there students have to say that the rules of interpretation oblique construction are classified into two. One is the primary rules and the second is the secondary rules. Under the primary rules, the following are being given, which can be used as a guides and which are very flexible in nature and which will help the courts while interpreting the statutes or while construction of the statutes. Right? What are the rules? The first rule is rule of literal construction. Second rule is the rule of reasonable construction. So construction, you know that, which goes beyond the interpretation, which means to say it tries to read, it tries to understand, it tries to discover the real intentions of the legislature, the real intention of the legislature behind making the statute, and it brings out to produce and it brings out to give the right judgment. The third rule is a rule of harmonious construction, which means to say if there is a conflicting interpretations, the courts will try to harmonize. It will try to amicably settle the dispute. And the fourth rule is the rule of beneficial construction. So, which means to say the positive way of reading the minds of the intentions of the legislature. And the fifth one is the rule of exceptional construction. Exceptional construction. And the last primary rule is that the rule of ejusdem generis. Ejusdem generis. So which means to say a paramateria. In the Latin word it says as the paramateria, which means to say the equal interpretation, the equal content wherever it is available, the interpretation will go on equal footings. That is what is ejusdem generis is concerned. So secondary rules, effect of usage and associated words to be understood in common sense manner. So common sense and effect of usage and the common sense manner is the secondary rules. Now we will go for the primary rules, and in the primary rules the first one is the rule of literal construction. The rule of literal construction, it is the cardinal rule of construction, so which says that the words, sentences and phrases of the statute should be read in their ordinary, natural and grammatical meaning, so that they may have effect in their widest amplitude. Right? Very simple rule it is. A cardinal rule. Cardinal rule, what it says is that the rule of construction is very simple, so that the words, sentences and phrases of a statute should be read in their ordinary and natural grammatical meaning, so that they may be have effect in their widest amplitude. So if you could able to write this thing, that will be sufficient. It is the gist of the rule of literal construction. You don't need to go through the paragraphs and paragraphs. Whether you understand the rule of construction is whether you understand it or not is the criteria for the examiner. So you have to know the rule of construction says that the words, sentences and phrases of a statute should be read in their ordinary, natural and grammatical meaning. So thereby what happens? It gives the effect in their widest amplitude. So that is what the rule of literal construction says. The elementary rule of construction has to be borne in the mind that the words and phrases of a technical nature and technical meaning, if they have any, otherwise in their ordinary popular meaning, right? So students have to keep in view what the rule of construction says that. And if you come to the words used in the popular sense, you will find some reasonable corrections or not to override some plain terms of these a statute, right? So, for giving the wider amplitude, so the different headings of literal construction are to be kept in view. That is the natural and grammatical meaning, and the explanation to it, and the exact meaning leading to loose meaning, the technical words in technical sense only to be taken. So these points have been elaborated here. Natural and grammatical meaning, statutes are to be first understood in their natural, ordinary, or popular sense and must be construed accordingly. So statutes are to be first understood in their natural, ordinary, or popular sense and must be construed accordingly to their plain literal grammatical meaning. So this is the a part which will give the literal interpretation, and the understanding of the literal interpretation can be understood under these four broad headings. And explanation of the rule, when it is said that the words are to be understood in their natural, ordinary, popular sense, it is meant that the words must be qualified, that natural, ordinary, popular meaning which they have in relation to the subject matter, right? And the third heading says that the exact meaning should be preferred to loose meaning. Exact meaning should be preferred to loose meaning. This is another point while reading the rule of literal construction. The exact meaning is preferred to loose meaning, right? Exact meaning should be preferred to loose meaning in the Act of Parliament. And technical words in technical sense. So the literal construction says that the technical words are understood in the technical sense only. For a technical words, you cannot give a general meaning or a popular meaning or an ordinary meaning which is prevailing among the legal fraternity, right? A technical meaning should be given the technical meaning only. So the second rule of construction is the rule of reasonable construction. The rule of reasonable construction. According to this rule, the words of the statute must be construed that words of the statute must be construed so as to lead to a sensible meaning. So, the words of the statute must be construed so as to lead to a sensible meaning. What is the gist of reasonable construction? The words of statute must be construed so as to lead to a sensible meaning. See, when you are writing about the rule of sensible construction, according to this rule, it should be said that the words of the statute must be construed so as to lead to sensible meaning. The meaning should be sensible. It should not be irrelevant. Right. So generally the words of a statute are to be given their ordinary meaning. They should be given the ordinary meaning. A statute must be construed in such a manner so as to make it effective and operative in the principle based on equality. The third rule is the rule of harmonious construction. The rule of harmonious construction. So, whenever there is a doubt about the meaning of the words of a statute, these should be understood in the sense in which they harmonize with the subject of the enactment. So they should harmonize, they should understood in such a way they will harmonize with the subject of the enactment and object for which the legislature had in view. So, what is the subject of enactment and what is the object of the legislature should be kept in mind while understanding the words of the statute, so that the construction will be harmonious. The construction will be harmonious. Their meaning is found not so much in a strictly grammatical language, nor even in its popular use as in the subject or in the occasion on which they are used and the object to be attained. Right? So, the rule of harmonious construction is to keep in mind the subject of enactment and the object of the legislature, which will resolve the issue. Right? So the fourth one is the beneficial construction. It is also known as a Haddon's rule. It is also known as a Haddon's rule, where the language used in a statute is capable of more than one interpretation. The most firmly established rule of construction is the principle is laid down in the Haddon's case. The rule, which is also known as a purposive construction. Purposive construction enables a consideration of four matters in construing an act. Right? What was the law before making of the act, and what was the defect of a law, and what is the remedy that the act is provided, and what is the reason for the remedy. So these 4 points are to be kept in view whenever a rule of beneficial construction is to be implemented. And the fifth rule is that rule of exceptional construction. So the rule of exceptional construction stands for elimination of statutes and words in statutes which defeat the real objective of the statute and makes no sense. Exceptional construction means elimination of the certain words in the statutes that will defeat the real objective of the statute or make no sense. There are certain words which doesn't make any sense in the bare act. So that has to be taken out, that should be eliminated, that should not be taken into account while construction of any statute, because it is going to defeat the real objective of the statute. You have to see, all the words in the statute need not be taken as it is when it is defeating the real objective of the statute. Dear student, you have to understand it with a common sense rule. You have to understand this with a common sense rule. And it also stands for construction of words like and, or, may, shall, and must. Right? It also stands for construction of words. So when you have to, whenever you want to eliminate the certain words which will defeat the real objective of the statute, then the construction of words like and, or, may, or, shall, or must, these things we can interpret it in such a way where the object of the statute is being protected. The common sense rule will facilitate for that, and may, must, shall, how it is to be used is also been given here. Right? So you need to know exactly what are the 5 rules if a question comes, and the last rule is rule of ejus dem generis, of the same kind. Of the same kind, simply stated, the rule means. So wherever an act enumerates different subjects, general words following specific words are to be construed with reference to the words that precede them. Right? So whenever the special words are being said after the general words, the reference to the words which precede to them should be taken for construction of a statute. For understanding of it, you have to see what the general word said earlier and what the special word is being given later. You should not go by the special word. You have to take into account the general word which preceded the second word while understanding the provision, right? These general words are to be taken as applying to things of the same kind as the specific words previously mentioned, unless there is a something to show that a wider sense was intended. Unless there is a need to see the wider sense, if it is intended, then only you have to go by the specific word meaning. Otherwise, you always should take the meaning of the general word which was preceded to the specific words, right? That is what the rule of ejus dem generis says. Now these are the six rules under the primary rules. Now we go to the secondary rules. So the secondary rules of interpretation. The secondary rules of interpretation, we will study it in the another session. I thank you all and have a good time with the best wishes as always.